A quiet set of court decisions just changed how gun laws work in real life, and most gun owners still have no idea. Pause. If you think your permit, your age, or your parts kit means the same thing today that it meant a year ago, you could be badly wrong. Quick question before we keep going. Are you subscribed yet? Because the next few minutes could save you from the wrong assumption. Walking into the wrong store, the wrong parking lot, or the wrong traffic stop could lead to an arrest. Hit that button now for this update. Here's what just happened. The title sounds like one court ruling flipped 8 laws overnight, but the truth is a little different. Honestly, the reality is even more important. A cluster of recent court decisions quietly moved the legal line in 8 different spots. Some of these changes are federal, some are regional, some help gun owners, while some tighten the rules. And that mix is exactly why people get confused. First thing you need to know, this is not a simple red state versus blue state story anymore. It is a map problem, it is a timing problem, and in some cases, it is a parking lot problem. Most people think, I know the basics, so I'm fine. But the truth is, one court can change what counts as legal in one part of the country. Meanwhile, another court says the opposite somewhere else. Let me break down the first change, because this one matters fast. In United States versus Rahimi, the Supreme Court said the government can temporarily disarm someone who is under a qualifying domestic violence restraining order. This applies as long as a court has found that person is a real threat to someone's physical safety. That means a lot of people who thought Bruin wiped out that kind of restriction were simply wrong. Why does that matter to you? Because after Bruin, a lot of people started saying almost every gun restriction would fall. Rahimi told lower courts, no, not that fast. The court basically said there is still room for gun laws aimed at people a judge has found dangerous. That shocked a lot of people, because the court did not say the Second Amendment is unlimited. It said history still matters, but judges can look at old rules that worked in similar ways. Here's the part most people miss. Rahimi was not just about one man. It gave lower courts a roadmap. If a law is temporary, it now has a stronger chance of surviving. If it is tied to a real finding of danger and aimed at stopping violence, the law is likely to be upheld by the courts. So if you heard somebody at the range say, all those disarmament laws are dead, that is just not true. Now imagine a real-world situation. You are helping a friend move. He says he cannot touch a gun because of a court order, but he thinks that is fake because the Supreme Court is pro-gun now. That is the kind of bad advice that ruins lives. If that order qualifies, possession can still bring serious federal trouble. Do not make that mistake based on range rumors. Second, and this is where it gets interesting, the Supreme Court also made a big move on ghost guns in Bondi versus VanDerStok. The court said the federal government can regulate at least some weapon parts kits and unfinished frames or receivers as firearms. In plain English, if a kit can be turned into a working gun quickly and easily, the government can treat it like a real firearm. This is the part that shocked me. A lot of people thought unfinished meant untouchable by federal law. They thought if a product was sold as just parts, then federal rules could not reach it. But the court said not so fast. If the kit is basically screaming what it is, and it can be finished without much time or special skill, the law may still cover it. So that is change number 2. Your old, it is only an 80% part talking point may not protect you anymore. And here is what most people get wrong. This ruling did not say every unfinished chunk of metal is a gun. It said some kits and some unfinished frames can be regulated. That gray area matters a lot to builders. If you are finding this helpful, imagine what you will learn in my next video about the 5 words that can protect you. Subscribe right now so you do not miss it, because these legal traps are getting more specific, not less. Third, young adults just got a major court win in part of the country, and almost nobody outside gun law circles noticed. In Reese versus ATF, the Fifth Circuit struck down the federal ban that stopped dealers from selling handguns to adults aged 18 to 20. That is a big deal. But here's the catch. It is not a blanket rule for all 50 states. Right now, the practical effect is strongest in the Fifth Circuit, which covers Texas, Louisiana, and Mississippi. So if you are 19 in Dallas, this ruling matters to you in a way it may not matter to someone in Chicago or Boston. Most people think federal law means the same thing everywhere, every time. But once a federal appeals court steps in, it gets messy. Let us say you're 20 years old and you watch one viral clip saying, court says adults under 21 can buy handguns now. So you walk into a gun store while visiting another state and act like the issue is settled everywhere. That is an expensive mistake. In one place, the sale might move forward. In another place, the dealer may still say no because the law has not changed there. So that is change number 3. For 18 to 20-year-olds, the wall moved, but it did not move everywhere. Now let us get into the set of changes almost nobody is talking about, because these can trip up normal concealed carriers. I am talking about Hawaii's carry restrictions in Wolford versus Lopez. Before you click away because you do not live in Hawaii, wait. This case matters because it shows how courts are drawing the new lines on so-called sensitive places, and other states are watching. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Here is change number 4. The Ninth Circuit said Hawaii could keep its default rule that treats private property as off-limits. It treats private property open to the public as off-limits for carry unless the owner says yes. Read that again. Not unless the owner says no. Unless the owner says yes. That flips the assumption many gun owners live by. If you walk onto private property open to the public, the default is no carry unless the owner has given consent. Most people think, if there's no sign, I am good. But under that rule, no sign does not automatically mean yes. Now, this is where it gets even crazier. Change number 5. The court allowed Hawaii to enforce its ban on carrying where alcohol is served. A lot of people hear restaurant and think family dinner. No big deal. But if that place serves alcohol, your risk changes fast. Change number 6. The court also allowed Hawaii to enforce carry bans at beaches and parks. Think about how broad that feels. You're not storming a courthouse, you're walking your dog. You're taking your kid to the playground or sitting near the water. And yet the legal answer may be very different than what your gut tells you. 73% of viewers are not subscribed. Don't be part of that group. Join the people who want the update before the stop, before the charge, and before the judge. Click subscribe and stay ahead. But wait, there is something even more important. Not every restriction in Wolford survived. Change number 7. The Ninth Circuit left an injunction in place against Hawaii's ban on carrying at financial institutions, like banks. That matters because courts are testing each place one by one. Change number 8. Some parking lot restrictions also got blocked. This includes parking areas tied to financial institutions and some mixed lots, shared by government and non-government buildings. The law is no longer just about the gun on your hip. It is about where your feet are standing when you park. The biggest danger is confidence based on old information. These 8 shifts move the line, and staying updated is the only way to be safe.